The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Thank you. Please be seated. 3 cases are submitted this morning. Those cases are State of Iowa versus Michael Cory Kelso-Christy, Rhonda Banwart versus 50th Street Sports, and In re the marriage of Lynn and Roger Larson. We'll now hear the arguments in State versus Kelso-Christy. Ms. Nye.
May it please the court, counsel. My name is Melinda Nye, and I represent Mr. Kelso-Christy and his appeal from his conviction and sentence for second-degree burglary. While the facts of this case arguably implicate complex philosophical and moral questions, the legal resolution of this case actually involves the relatively straightforward application of a previously interpreted statute. In 2006, this court addressed whether consent to sexual acts obtained by fraudulent means was valid consent in State versus Bolsinger. This court concluded that such consent was valid legally and that the resulting sex acts did not constitute sex abuse. In the 11 years since, the legislatures have been aware of the Bolsinger decision and has declined on 6 occasions to amend the statute to include fraudulently induced sex acts as sex abuse. In this case, the defendant pretended to be someone he was not and began communicating with SG. Throughout the course of a day or so, the communication continued through text and social media.
Well, didn't the defendant do something more than just pretend to be someone that he was not? Didn't he devise a scheme that denied the victim the opportunity to make an assessment of who he was?
He created a Facebook page under the name of someone else. It sounds like this is a small town. They all went to high school together, and so they were all friends on Facebook prior to this. I don't know. It's not clear how much they all kept in touch, how close any of them were, but he created the Facebook page under someone else's identity, and then so they communicate through the day through this Facebook page, and then through text messages. He gives her his real phone number, and they communicate via text, and then they ultimately arrange a sexual encounter for that evening.
Oh, and this blindfold thing.
Exactly, and where she would be blindfolded, precisely.
Well, isn't that different than just him deceiving her as to who he was? That there was also a scheme that took away her ability to look around and assess who
Certainly,
he was?
I mean, that was part of it, that she wouldn't, obviously didn't want her to see him, but that was the agreement. That was the possibly the interest, part of the interesting part of the sexual encounter to her as well. She agreed. She was fully aware she was going to be blindfolded and agreed to it, and it occurred as planned, exactly.
But she didn't agree to have relations with Kelso-Christy. She thought he was somebody else.
Exactly. She at all times she believed it was someone else. It was Mr. Poe that she was talking to.
Is Bolsinger controlling? Isn't there a difference between faking a different identity of someone else versus just misleading the victim about the nature of the examination or procedure or what you're asking them to do?
Bolsinger, in the end, Bolsinger held that the boys had consented to be touched in a specific manner, and they were touched in precisely that manner. And in this case, she consented to particular sex acts, and those particular sex acts occurred. The fact that it was somebody, that she thought it was somebody else, doesn't change the nature of the acts, doesn't change that she consented to particular touching and particular actions. So arguably, certainly she would have liked to have known who it was. It might have been important, but I certainly, those boys in Bolsinger thought it was important to know that they were being touched for a sexual purpose and not a medical purpose.
I mean, the law seems to draw this distinction between fraud in the factum and fraud in the inducement. In other words, not all, there are some frauds that are sufficient that you can still prosecute the crime. Mm-hmm. Now, I didn't know anything about fraud in the factum with regard to sexual abuse, but I do think I have some understanding of fraud in the factum in the commercial area. And in that area, the way it works is if you're presented a document and then you're to sign, let's say, a promissory note, and you're told, if you sign this note, I'll paint your doorway, and you sign the note, and the person doesn't paint the doorway and never intended to do that. That's fraud in the inducement. But if you're presented a document that's a promissory note, and you're told, this is, I just want your autograph, or this is just signing something to confirm that you're the owner of this house. I mean, so that would arise to fraud in the factum, and that would be a defense in the commercial field. Now, applying that analogy, which I think Judge Scott did in his opinion for the Court of Appeals, why isn't that fraud in the factum? Because this person it has no clue at all who the person is that she's actually ends up having sex with.
Mm-hmm. Certainly, the distinctions made, that's the analysis that the courts applied. I think she agreed to particular sex acts, and that's fraud. I mean, that's what happened. Those sex acts occurred. And so the fact that that the person was someone different than she thought she was agreeing to, she'd actually had these real communications with Kelso-Christy and set this, arranges.
By analogy, the person agrees to sign their name. I mean, the physical act is not in dispute. What is in dispute is the kind of the level of the fraud. And why isn't this that kind of fraud where I think everyone would agree the identity of the individual is totally fundamental. This isn't lying about how much money you make or whether you're married or not or something like that.
First, I'm not sure it's a universal truth that the precise identity of a sexual partner is the fundamental fact. I know some courts have concluded that it was. I think that's, there's other courts that have concluded it's not, or that in this kind of a situation it's not. I still think this is not the same as, asking for an autograph and it's really a legally binding contract is like, the examples given in Bolsinger. I'll touch your leg and then actually, touch your genitals. Those are separate acts, and I think this is the same. The sexual act is the same as what's agreed to, and the precise identity of the partner doesn't change the nature of the act and what was agreed to.
What do the courts in other jurisdictions say on this issue?
They are all over the place. I think, this is absolutely, it's a fascinating, like I said, a fascinating philosophical and moral question. There's a lot of criticism for how rape law is handled in this country. So courts come out on both sides of it, and the state and I have both cited some of those cases. But I think something that is important to remember is that, of course, every court is interpreting different statutes, and there are a handful of states that have explicitly outlawed sex procured by fraud and categorize it as sex abuse. Other cases.
Can you tell me, under this statute, where this fraud comes in? I mean, we're bound by the language of the statute.
Exactly.
And where does the statute talk about fraud in the inducement or fraud per factum? I think some of the courts have said, we got to go to the language of the statute. We can't start making up stuff.
Exactly. The statute prohibits sex that's against the will or by force. There's at 709.5, I believe, adds that it describes that the physical resistance of the victim is not necessary, but that the court will look at all of the surrounding circumstances to determine whether it was in fact by force or against the will. And so the court had that language in front of it in Bolsinger and applied this fraud in the factum, fraud in the inducement analysis. And this is sort of the traditional test that's been applied by courts through the years. Again, there's criticism of whether that should be applied, whether there should be a different approach that's applied. The thing with this is that we have Bolsinger, and this is the analysis the court applied, and the legislature is well aware of Bolsinger. They looked at amending the statute, and notably the language that they proposed would have just added another category of sex abuse, fraud, or sex obtained by fraudulent misrepresentation.
Can't we draw a pretty clear line that if you lie about who you are, if you impersonate someone else, that's different than simply lying about your age or puffing or about your accomplishments or what you can do for the victim?
I don't think that line can be clearly drawn. When you start talking about identity, how is this different than the situation if they'd met at a party and he said, hey, I'm your old friend from high school, don't you recognize me? I look a little different, I've lost some weight, I've grown a beard, or I'm a celebrity, I'm Bradley Cooper, and I look like this because I've, this is still someone known to her, a celebrity or a former classmate, and it's still, then you still got this representation about identity, and then you start down the slippery slope about, well, is your identity your marital status? Is your identity just your name? Is it your social security number? Is it your influence? How do you define someone's identity? I don't think it's as easy as it seems at first blush to draw that clear line.
Was Bolsinger correctly decided? Under that case, would the U.S. Olympic team physician for the women's gymnastic team, would he walk free?
I don't know the precise acts that he's accused of. I'm sorry, but first of all, under Bolsinger, Bolsinger distinguished cases where someone consents to a medical procedure with medical instruments, and then in fact the doctor has sex with them. That those are different situations, because that's not the same act. They didn't consent to a sex act or to be touched in that particular manner. They agreed to different touching, and so that would be fraud in the fact. And whether you like Bolsinger or not, Bolsinger was decided, and ultimately the pole star of any statutory interpretation, of course, is legislative intent. And we know that the legislature is aware of Bolsinger and did not change it. This is more than normal stare decisis, where you have a presumption that the legislature is aware of the court's decisions and fails to act, and so you presume that the legislature approves of the court's interpretation. We know that the legislature is well aware of Bolsinger and has specifically decided not to start down that slippery slope of fraudulently induced.
Well, Bolsinger wasn't identity fraud, though.
Correct.
So we don't
it was
know
not.
if the legislature's weighed in on that, do we?
I think it's the same. They decided not to start. They didn't say your analysis was wrong. They would have just created a different category that fraud. So the analysis of fraud in the fact and fraud in the inducement. Certainly the court could say, this is different. This is what the lower courts have said. This is different. This is fraud in the fact because identity is different. But I think identity is hard to define, and how you can say it's different. It's not just a matter of what's important in making a decision to engage in sexual behavior, because, as I said, certainly knowing that you're engaging in sexual behavior is vitally important, and probably more important than the identity of the sexual partner. Yet Bolsinger was decided the way it was, and the legislatures approved of it. So I think I don't know how, Booker, for example, some other courts that have said that a case like this would be fraud in the factum would have also said Bolsinger was fraud in the factum. And so I don't know how you get around Bolsinger and the fact that the legislatures approved it ultimately. I guess to close, because the evidence was insufficient under Bolsinger and previous interpretations of the statute, the evidence was insufficient to support the element that Mr. Kelso-Christy intended to commit sex abuse when he entered SG's home. And we ask that you vacate his conviction and remand for dismissal. Thank you.
Ms. Nye, thank you. Mr. Buller.
May it please the court. There are two fundamental components to sexual consent. The first is what you agree to do, and the second is who you agree to do those things with. The first in general seems to be easier for us to wrap our minds around. If you agree to hold hands with someone.
Oh, wait a minute, the statute, the statute talks about a sex act as being done by force or against the will of the other. In order for this series of acts to fall within the statute, it's either done by force, I don't think you quite argue that, but maybe you do, or against the will of the other. I think, help me if I'm wrong, as I know you will, but I think you're really relying on, well, this is against the will of another. Right so far?
I agree with that, but against the will does mean consent. That's what this court has consistently said.
Well, but if you look at Bolsinger, and look at the language in Bolsinger, if an act is done, I'm reading from it, if an act is done that is different from the act defendant said he would do, then it's fraud in fact. And then, ... a few paragraphs, we conclude that the consents given here were based on fraud in the inducement, not on fraud in fact, as the victims were touched in exactly the manner represented to them. That's just what it says. So the principle in Bolsinger is if you touch someone in exactly the way represented, that is not fraud in fact. Now, you might disagree with it. Then you might say that's wrong, and I think from my looking at the cases, it's fair to say it's scattered all over the place. Other jurisdictions.
There are certainly inconsistent decisions. I will give you that.
They're all over the place, and the statutes differ. But the principle of Bollinger is that if the acts are as represented, I think, then it's not fraud in fact. Now, am I wrong? Or do we, maybe we throw Bolsinger out, and you've suggested that in part and brief, and that's fair enough. But it seems to me the principles of Bollinger rather strongly support your opposition's position. So you understand where I'm coming from?
I do. There's a lot in there I want to address. Justice Apple, bring me back if I don't get to your question. But what I want to start off by saying is that Bolsinger is wrongly decided. There is no question in my mind that that is a fraud in the factum case, just like State versus Van Der Esch was. In order to accept that what happened in that case was not sex abuse, this court would have to conclude that body parts and penises are just interchangeable. Or as Ms. Soich more elegantly puts it in the brief, that sexual partners are a fungible commodity. As long as somebody got touched and they expected to be touched, it's all okay. That does not square with our understanding of consent. It doesn't square with even the legislature's intent with the code revision when they passed Chapter 709.
Well, then why didn't the legislature, fix it? They're very prone to fix decisions of this court, particularly when they involve sexual offenses. That's not, if we come out with what's perceived as too narrow, a ruling that the legislature doesn't like, they fix them pretty quickly, often.
Sometimes.
Sometimes, but apparently not here. There's been a considerable period of time and multiple efforts to do so. How does that fit in the mix?
First, I think the defendant really is overrepresenting the strength of legislative action. In the brief, the defendant suggests there were 6 attempts to make a change about Bolsinger. That really isn't true. There was one study bill that had a House number and a Senate number, and it happened to be held over in consecutive General Assemblies. It's not like there were 6 different attempts to fix this. And I think the reality is no one is quite sure what changes to make to the statute to address Bolsinger, because against the will, as this court interpreted it in Myers, certainly, would reach the conduct here. And more importantly, trying to reconcile Van Der Esch and Bolsinger really is just impossible.
But there were a number of states who had similar decisions as Bolsinger, and then amended their statute to put deception in there.
Sure, and
to take care of it. So to say that they weren't aware of the problem, and if, you know, they belong to these associations where they talk about other states to take care of other problems, and other states have done it after similar decisions as Bolsinger, but ours didn't do it. And I think you have to credit that somewhat and not poo-poo it.
well, let me talk a little bit about the other states that have basically said this may be a crime, but it's not the one charged. We invite the legislature to act. One of those is Massachusetts, which defines rape as by force, period. There is no against the will alternative. That statute is materially different than ours. The Massachusetts court never would have said what this court did in Myers, which is that the linchpin of 709 is consent. And I do want to talk a little bit about this argument that because it's not explicitly listed in 709.4 as one of the alternatives, it's not reached by the statute. This court has expressly rejected that argument, and Myers is one of the cases where this court did so. Myers dealt with what I think we can fairly coercion rather than physical coercion. The court conducted its analysis, looked back to the code revision. What is the purpose of 709? The purpose is consent, to make a meaningful decision about sexual activity.
But if you look at the statute, the second sentence says when consent is not consent. And they don't have deception in there. I mean, by leaving it out of that list, I mean, what do you make of that?
Well, this court's rejected the argument that the list is exhaustive or exclusive. This court has said that it's illustrative. And of course, that is what we see with the prefatory section, that it is by force or against the will. Chapter 709 is intended to reach a wider range of conduct than common law rape.
Let's say we want to leave Bolsinger as is, or we feel compelled to do so, or just don't want to address it. Can we still say that this is different because the person didn't know the identity and affirmatively consented to someone with a different identity? Is that a difference?
There's absolutely a path this court can take to affirm the conviction in this case and leave Bolsinger intact.
And that leads to my next question. There was a movie many years ago, you're probably too young to remember it, is with Jodie Foster and Richard Gere. Richard Gere is a soldier in the Civil War, and he comes back and pretends to be Jodie Foster's husband, who was also a soldier in the Civil War, but who was killed. Mm-hmm. And he looks like the other guy, and apparently he, fools her. Is that sexual abuse under your definition?
I think there are two approaches the court could take. One is a narrow definition of identity, that identity means these are the physical body parts that you have agreed to have touch you. And in your example, it sounds like Jodie Foster agreed that this physical body could touch her. Under that narrow definition of identity, that would not be criminalized versus the facts in this case would be. But I would suggest to the court that's really an outdated way to look at someone's sexual decision-making. Myers recognizes that our statute, Chapter 709, is a progressive statute. It sweeps far wider than common law rape. And I think as you look at the Military Court of Appeals decisions, for example, a fundamental component of making a decision about sexual activity involves who you're having sexual activity with. Like I started off by saying, you have two components, the things you agree to do and then who you agree to do them with. I'll absolutely give up
under the way the state wants us to interpret this statute, I mean, there's twin cases all over the country where it's one twin and another twin. Those would all be, under the Iowa statute, sexual abuse.
Yes. And I want to talk just a little bit about those
What happens
cases.
if you say I'm a doctor, but you're really a lawyer, and the person wanted to sleep with the doctor? Is that sexual abuse? Because you're misrepresenting who you are. You didn't agree to go to bed with a lawyer. You agreed to go to bed with a doctor, under your definition.
And that leads me into why I think the law's developed this
Well, is it sexual abuse? You
I think
shook
we
your
need
head
more-
yes.
We'd need more facts to really evaluate that. Is that the only piece of information that was misleading? And was it material to the victim's decision about whether to consent? For the most part, a statement about occupation is in that category of white lies and minor deceptions that we accept. The law of fraud has a word for that. It's puffery. That if you exaggerate, if you say that you're 10
You
pounds lighter.
exaggerate that you're a doctor and you're a lawyer. How's that exaggeration? That's an outright lie.
That is the kind of statement the law has generally recognized is acceptable in, the barfly kind of context. The analysis, I do think, changes significantly if you represent yourself to be a doctor in order to conduct what you claim is a medical examination, but it's really for your sexual gratification. And of course, that is the facts in Bolsinger. The boot camp instructor tells the boys, I'm going to touch your genitals, and it's for purposes of a medical treatment. It's a pathological examination. Of course, the boys have no idea that in reality, this is a person who possesses child pornography, and he's doing it for his own fun rather than any medical purpose.
Mr. Buller, it sounds like you're saying the statute sweeps even fraud in the inducement. Is that your position? Not just fraud in the factum?
Of course, no one can really agree what is fraud in the inducement and what is fraud in the factum.
If
Maybe
that's
we
the
need a
case,
legislative resolution of that.
yeah, if that's the case, then doesn't that create a problem for the state, because there needs to be notice to people of what's a crime and what isn't?
No, I don't think that is true for a number of reasons. But the first is that the fraud in the factum, fraud in the inducement distinction is absolutely court-created. That's not a legislative problem to address. What I think the purpose of the fraud in the inducement line of case law is to set aside this category of white lies and minor deceptions, say that is off limits. Fraud in the factum addresses when there are material discrepancies between what you agreed to do and what
And
happens.
that would not be the case in commercial law. I mean, you're
I
not.
agree with you about that.
But all right, so then in your case, in your example, if someone lies about their marital status, I don't think you would say that's not material, would you?
For purposes of discussing sexual consent, it is probably not material. Of course,
I'm sorry to interrupt you, but I have obviously. But if a person says, I don't sleep with married people, and there's credible testimony to that effect, and somebody says, well, I was single, turns out to be married, under your framework, wouldn't that be a problem?
the law has historically said that that kind of deception is permitted. And I think that's where this fraud and the inducement line of cases comes from. I think a better, more progressive reading is what this court said in Myers, that it's about material elements, information that leads you to that consent decision. And let me, just because I'm running down on time here, offer that there's even a more narrow way in this case if the court wants to preserve both the fraud and the factum distinction and Bolsinger. This court could say identity is just different. I think that's what the court...
Well, counsel, even... it strikes me that your case, that the nature of the deception in this case is, qualitatively so important that we have to find there was no consent here some way, is a real challenge because the victim in this case agreed by consenting to the act to be blindfolded. It appears that the identity of the person she was interacting with wasn't as important as you might suggest.
Well, I don't think that is true at all, Your Honor. In fact, the victim called the police almost immediately once she realized that the person she had sex with was not Slater Poe, but was rather the defendant who had impersonated him. I really don't think it's appropriate to hold it against the victim or blame the victim for putting on the blindfold. She thought she was agreeing.
No, this isn't a matter of blame. It's a matter of discerning what it is she consented to, And by agreeing before the transaction ever occurred to be blindfolded and not to be able to see the person she was engaging with, seems to suggest that under the peculiar facts of this case, the identity of the person was less important than it might otherwise be.
There is no support for that conclusion in the record, and to the extent what we're really asking is, what did the victim consent to? That is easy to answer here. The victim here consented to sex with Slater Poe. She never agreed to sex with the defendant. In order to accept any argument that it's okay that someone else had sex with her just because she agreed to sex with one person, this court would have to find that penises are interchangeable. This court would have to conclude that sexual partners are completely fungible. The law has rejected that notion in Iowa going back to the code revision, going back to 1978. Consent to sex with one man is not consent to sex with every man. I would ask this court to affirm.
Mr. Bowler, thank you. Rebuttal?
I'm not sure I have much to say on rebuttal, frankly.
Well,
I'm ready for questions.
let me ask a question
Yeah.
then. You know, it seems like we started to address this issue by making a distinction between the type of fraud, whether we're talking about fraud in inducement or fraud in fact.
Mm-hmm.
But if you look at the statute or the statutory language that is before us, it's a sex act against the will of another.
Mm-hmm.
So if we focus on that concept, we're focusing in on a broad encounter, which would include when the sex takes place, where, how, with who, everything that goes into this encounter. For instance, if you might consent to sex at one time but not at another time, that would be protected. I assume when you don't want it, it's against your will. Mm-hmm. I'll do it here but not here. We're going to protect that. I'll do it this way, not this way. We'll protect that. But why don't we extend that same protection when we're talking about with whom? I'll do it with this person but not with this person. But when we get to who, all of a sudden, well, then we're going to analyze this in terms of fraud. But why is fraud even relevant here? If someone is unable to assess and is deprived of the opportunity to assess who the person is.
I think there's...
I mean, some guy could say, I'm the 6th wealthiest man in the world, and trying to impress someone. But at least you go in with your eyes open. You can make an assessment.
I think there's a couple things. First of all, just because, as we've discussed, identity is hard to pin down. Even in your example of the 6th wealthiest guy in the world, if that's, that person is still being deprived of all the information he or she wants to make that decision. And so I don't know how that's, different than this case.
Well, shouldn't the law of consent protect every component that goes in to that consent?
I think maybe, but I don't think that our statute does, and I don't think
Well, we don't say maybe when it comes to what time of the day you're going to give your consent. No means no, right? So why would we then draw this distinction when we come to the component of who?
I think it's because that's easier to the time of day and the particular acts. Those are things that can be compared and easily identified or easily determined whether they're the same as what was consented to. When you start getting into identity, it starts getting a lot messier. The other thing, frankly, is this is how the law is developed, and this is how we get to again, whether it's right or wrong, whether we could have an entire semester law course on what rape law should be and how and what the real issues, to be protected, and whether the law is based on old sexist notions of women's virtue, and like I said, it's a fascinating topic, but that's for the legislature to decide. The legislature has failed to amend this in any way to start down that slippery slope that becomes allowing or criminalizing fraudulent inducement of sex acts. And so
Does the
it's-
rule of lenity help you? I mean, should somebody go to prison if it's unclear their conduct would send them to prison?
I think that's absolutely, that definitely helps the defendant in this case, that it's not, that with Bolsinger as the law, that you start getting into, it starts getting a lot more complicated to know when their conduct crosses that line, when it's a matter of identity, misrepresentation of identity or some part of identity.
But why was the Court of Appeals wrong in saying that the identity of one's sexual partner is material and essential to the person's decision to consent? I mean, she had some kind of a emotional bond with her classmate and thought she was consenting to sex with her classmate, not the defendant. Isn't that different than Bolsinger?
Well, first of all, it's not clear how much of a bond she had. This wasn't her boyfriend, but yes, certainly she thought it was somebody she thought she knew. She knew everybody. Everybody knew everybody in this town. But she says it was material. She found out the next day. She was mad. It was material and important to her decision. But I think that's the same thing. You say the same thing about the kids in Bolsinger, that certainly that was material and critical to their decision to consent to be touched in a certain manner, to know that it was a sex act they were consenting to and not a medical procedure. And unfortunately, that's not the determining factor, is whether it's important or material. This isn't, it's not a contract. It's different. It is different that's the way rape law has developed, and that's what the legislature's condoned over the past 11 years. Thank you.
Ms. Nye, thank you as well. The case of State versus Kelso-Christy is now submitted then, and we'll hear the arguments in Banwart.